Yes, so it's a little bit refreshed.
Thank you, my lord. So I was taking the court to Article 67 and its predecessor, Article 73 of 1408,
Yes.
and my submission was that that provision reflects the fundamental principle that family benefits are paid by the state whose legislation is applicable. And I mentioned just before lunch the case of Moser.
Yes.
I don't invite the court to turn it up. I've given the court the page reference. That's a case about a classic priority situation where two parents were each working in a different state. So there were two rival applicable laws, which is the paradigm situation where the overlapping type provisions kick in. That's what Moser is about, but along the way the court deals with Article 67 and how it relates to Article 73. It essentially says that they are identical.
I see.
So back then to the legislation and Article 68.
Is Moser in our bundle?
It is. I'm so sorry.
Yes.
I didn't.
Yeah, it's my fault.
It is tab 19.
There we go, thank you.
And I think you told us that the relevant bit was...
I think it was paragraph 35.
36.
36.
Yeah.
Yes, paragraph 36.
Thank you.
The passage starts at Article 67, paragraph 35, and the court will see in that case that's an example of the court grappling with how the substantive provisions in 883 interact with the provisions in the implementing regulation, and the court giving meaning to them as a coherent whole. But the actual issue in that case doesn't help in this case. So back then to the family benefit provisions in 883. We've dealt with Article 67. Article 68, priority rules in the event of overlapping. Now, my primary submission, as the court knows, is that we don't get there, but just to talk through Article 68, it is a complex provision, as one would expect, but essentially what it does is set rules of priority for classic conflict situations. So the paradigm example that I gave of one parent working in France, the other parent working in Spain, both parents are entitled to family benefits under the applicable law of France and Spain because they're both working. So you've got two rival applicable legislations. This then sorts it out with the help of the implementing regulation. So it's got different rules depending on the basis on which the benefits are paid. So subparagraph A deals with benefits payable by more than one member state on different bases, and then B is benefits payable by more than one state on the same basis. And the court will see that there's an order of priority, so where they're payable on different bases, it's activity as an employed or self-employed person which comes first.
What does bases mean?
It's
payable?
HMRC begins by looking at the basis on which the state is competent, but what will then happen under the implementing regulation is there's a discussion between the states. So the state, the way that it works is the state to which an application is made has a look and decides if its legislation is applicable by priority right or not. If it thinks it is, it pays, but it gets in touch with the other state. I'm turning around because this is mechanics. If it thinks it's not responsible, it writes to the other state and it notifies them, and we submit that works as a claim in effect. And then there may be a discussion between the states which would involve to some extent the states explaining to one another the bases on which the benefits are paid. I'm looking behind me, and then if they have a big row about that and they can't decide, then it would go off to the administrative commission. There would be a dispute, but on the whole, as I understand it, it generally works without issue. That they sort out this by applying these provisions together with the provisions in the implementing regulation, which I'll take the court to in a moment. The one...
Sorry, and the concept of a basis just means effectively what are the
Yes.
preconditions which have to be satisfied, is that right?
Can I turn my back?
Yes.
Yes, I just read on. I hadn't read in, but it says there, isn't it, on the basis of, on the basis of, on the basis of.
Yeah.
Yeah.
Yes, quite.
I'm being told that if the person is working, then it becomes benefit payable on the basis of work. Here we say that benefits were available on the basis of residence.
Rights obtained on
Because-
the basis of residence.
Because she was simply resident. She wasn't working in Spain. Mrs. Carrington was simply
Yes.
resident there. But if Spain then said, well, that's not how it works, I'm going to take a different view, that's when there'd be a discussion and ultimately a dispute in the Administrative Commission. But that's certainly how HMRC apply the provisions.
What is 67.2 all about?
67.2 is about making sure that somebody doesn't lose out. So supposing in my example, one parent in France, one parent in Spain, and supposing Spain's legislation is applicable by priority right, and Spain only pays
okay.
£200 a month, then the secondary state has to pay a top-up, in effect.
Except where the entitlement is based on residence
Is residence only.
only. Wow.
So, could I just turn my back
Hang on.
again? Yes, so ours is based on residence only. We don't require somebody to be working to get family benefit or anything like that. So in that situation, obviously for states who have residence-based benefits, this regulation is by and large crafted to protect them. There are other provisions which do that in relation, for example, to pensioners, because states who don't charge contributions for paying benefits will obviously end up spending a lot more money than states which have charged contributions for paying them. So that's why that protects a state whose entitlement is based on residence alone. It doesn't then have to pay that top-up. And the court will see again that Article 68 uses the language of a state whose legislation is applicable, albeit not by priority right. So it's very much reflecting the language of Title 2 on applicable legislation.
Yes. Sorry, just before I forget, this is a very basic question. I mean, regulations are obviously promulgated in all the different languages of the community. Is there any provision that one language prevails? Or they're all equal, aren't they?
Generally not in the
Yeah.
EU law, yes.
Yes.
They're all equal.
Yeah, thank you.
So that's the main provisions. We don't need to worry about Article 68A, but what that does is basically says if family benefits aren't being used by the person to whom they should be provided, the competent institution can provide them to the person who's in fact maintaining the members of the family at the request either this and through the agency of the institution in their member state of residence, or by the designated institution. So that just covers a very special situation. And then Article 69, again, doesn't need to trouble us. It's about special benefits for orphans. And what the court will see is that that's worked out by looking at the legislation to which the worker was subject for the longest period of time. In other words, you have to compare the periods to the periods of applicable legislation to work out how to pay those benefits. So again, it is premised on applicable legislation.
Just thinking out loud, Article 68, we're assuming it covers a situation where you've got two parents in different states and you're working out which state first and how do you deal with the differential. Why wouldn't it apply if the respondent is correct and you could have a situation where you could claim in the state that you came from or the state that you went to? Arguably, that's a situation of overlapping entitlements, if they're correct and you can get it from the first state. I understand the arguments about applicability. And then if that were the case, Article 67.2 presupposes that you'd get it in the place where the children were resident, and then after 67(2 would say, if England is more than Spain, we would have to pay for Spain, but not when they were resident in Spain, because the assumption is if they're living in Spain, the benefit in Spain is fixed for the costs in Spain. So why doesn't Article 68 potentially cover a situation if you're wrong, and if it's not one state only, you can have different benefits at different times?
Then that's my ground too.
Oh, is it? Oh, sorry.
Yes, no,
We lost the will to
I'm
live.
very grateful
Sorry,
to the
Miss
Lordship. The quarrel on ground two is really how far that protection goes for the
Yeah.
paying state because of the Schwemmer line of case law.
Right.
There probably isn't a lot of dispute between the parties on ground two in principle if I'm wrong on ground one. What the Schwemmer line of case law says is the benefits aren't, that there isn't an overlapping entitlement essentially unless the person meets all the conditions under domestic law. So in a situation where we say the applicable law principle is prime, it to some extent places the choice in the hands of the applicant, although HMRC's practical answer to that, which I've referenced in the skeleton, is as part of the notification requirements, that because this is an old case and we can't find the papers, we can't say happened here, and probably didn't because we found out 2 years later. But normally, if I'm wrong in ground one and ground two is my fallback position, HMRC's position is that what it would do is notify the other state that it doesn't consider its legislation is applicable by priority right, and that would be good enough to be a claim, which would then fix. So in other words, the person wouldn't really have a choice because to the extent that a claim needed to be made, the state whose legislation wasn't applicable by priority right, assuming it applies here to us, would make that claim in effect. So that is how HMRC, if it loses on ground one, will say how this works under ground two.
Yeah. I'd forgotten about ground two completely, I'm afraid.
Yes, it's, my primary position is applicable law, but if that's wrong, I do submit there has to be some way to sort this out because it simply can't be right that the first state just pays endlessly, and indeed that the recipient themselves might not want that, and it isn't in the interest of free movement. So if I fail on ground one, I do submit that it has to be sorted out by Article 68 in the way that your Lordship says and in the way that I've just submitted.
Well, it may also point to the answer to ground one, I suspect you'd say, because it shows that in cases of child benefit, there's nothing wrong with the state where the children are living, paying it, C67(2), for example, and it shows that the basis of the differential treatment, as I've called it, is not residence per se, but the legislative provisions, be it Article 11 or Article 67. Yes, I'm sorry, I'd forgotten ground two. Do beg your pardon.
I've forgotten many things in this case, but I hope I remember my grounds. But I'm grateful for your Lordship's intervention. Yes, and one point I would make is to the extent that it can be said, well, Article 68 wouldn't bite. If I'm wrong on ground one, if it's argued against me that Article 68 couldn't bite in an Article 7 type situation, that simply reinforces my case on ground one.
Yeah.
Because it's right to say that Article 68 on its face, that it more naturally applies in that situation I submitted where there were two states, or in an Article 67 type situation, as we'll see. But nowhere does the legislature make provision, and we'll see in the implementing regulations, for how this should bite in an Article 7 type situation. And that, in my submission, reinforces my ground one. But if I'm wrong, in my submission, the only possible answer that could make sense is to apply Article 68.
The problem is we don't actually have any evidence as to whether or not the legislation of Spain does provide for benefits for the child in this case.
No, if I win on ground one, that's irrelevant.
Doesn't matter, but if you win on ground
but
two,
she's protected, of course, because we accept we didn't take that point in the upper tribunal, and we therefore deprived her of the protection of them being able to go to Spain and for us to have discussed with Spain. So that's that. In relation to ground two, again, there wasn't that discussion between states for the reasons I've given, but we submit that the court's asked to give a judgment on the point of principle, and then we would submit that to the extent that an application needs to be made, if it's necessary in that state, HMRC will do that by making the notification, so that's to sort of fill the court in. But again, I accept, even if I'm right on ground 2, we're paying her whether I win or not because of the way that matters have played out.
Yeah.
So it's essentially the point of principle.
But the judgment will be conditional if, in fact, the other member state has legislation which provides for the same benefits. Then Article 68 would apply. We just don't know about Spain.
Yes,
and you
exactly.
could have asked under Article 76
Yes.
that you could have got the information
Yes.
quite easily.
Yes, so HMRC's position is as set out in my skeleton,
Yeah.
which is that benefits would have been available in Spain on the basis of her residence because she wasn't working there, but Spain might say, well, we don't agree, that's not how we think this works, because in our legislation, blah, 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 and I can't, of course, tell the court what would have happened because it didn't happen, so we're just in the principle.
I mean, the one thing I don't think we can do, unless you persuade me otherwise, is rely on slightly throwaway remark of the judge in the upper tribunal was amounting to a finding that there was somehow a similar system of child benefits in Spain when there was frankly no evidence at all on the subject.
No, what I would submit is it's for anyone who works in this area, and it's recognised by the Commission in its guidance, all states do provide for some form of family benefit. But the point that Judge Jacobs made in relation to ground 2 was that she hadn't been awarded it.
Yes.
So it doesn't count.
Right.
And my submission is no, it's wrong to look at award. What one has to do is look at entitlement conditions, see
Yes.
Schwemmer. But we can't take it any further than that here. But I entirely accept what your Lordship
No,
says.
I mean, so often the devil is in the detail with these things, and unless, you know, and anyway, these are
Indeed.
questions of fact, aren't they?
Indeed, which the court grappled with on some occasion, and the point that I made is, of course, the main fact is that it's common ground that she changed her residence and that the applicable legislation changed.
Yes.
And that may or may not resolve the case depending on the court's decision.
In the normal way, if in a case of this nature one needed to adduce evidence about the legal system in another member state, I mean, that wouldn't be a matter of community law, it would be a matter of foreign law, and so it would need expert evidence, presumably, wouldn't it? And it would be technically a question of fact for the court to determine if there were a dispute.
Although the reality is, had there not been this issue about the UK saying, well, we're not competent because the applicable law has changed, it wouldn't have ended up in the upper tribunal at all, because the UK would have discussed with Spain, and it wouldn't then have been in the upper tribunal. That's the point. So it's if we're wrong on ground 1, and it's just ground 2, then it's much more likely to have been resolved between the states, and it couldn't have got into the upper tribunal, I suspect, because if there'd been a dispute, it would have gone off into the admin commission, or I suppose the respondent could have said, well, I don't care, I don't want Spanish benefit, and then that would have ended up in the upper tribunal, and then that would have been a different argument. I'm just turning around, getting a nod.
And the recovery, because he wanted the money back too.
We're not seeking. We're not.
No, initially. How would that be dealt with?
I'm so sorry.
How would you get the money back? You say that you paid, I forget, £1,700 already.
Yes.
You wouldn't have been notified that she moved to Spain, and therefore you paid it. So how does recovery come within this scheme?
The HMRC makes an overpayment decision. I think your Lordship's asking about the mechanics of resolving it under this legislation.
Yes.
I don't know, but I will find out.
Yeah.
So that is then the basic provisions, but they're supplemented by the implementing regulation, tab 2. And there are various provisions also in this regulation about cooperation between states. But I'll just ask the court to look at the specific provisions on family benefits, which begin on page 160, chapter 6. We don't need to worry about Article 58 in this case, but Article 59,
Sorry, did you say page 106?
You meant 137, I think.
160 in tab 2.
No, I think it's 137.
Well, sorry, what are you trying to take us to? I mean, mine 160 is just a list of
Sorry,
Denmark. Doesn't seem at all relevant.
tab 2.
Yes, I'm in tab 2. I think I am. Yes. Is this bundle page 160? Or
Yes.
It's 136 and 37 in mine. It's chapter 6, headed family benefits, article
Yes.
58. Is that it?
I'm so sorry. I've
136.
got different pagination. And I think that's my fault entirely from bringing in something from a previous bundle. I do apologise. Let me use the correct pagination.
Well,
yes,
tell us the
I'm
article.
sorry. 137, Article
thank you.
59.
Article 59. Yeah.
So Article 59 headed
Yes.
rules applicable where the applicable legislation and or the competence to grant family benefits changes. Article 59(1), where the applicable legislation and or the competence to grant family benefits change between member states during a calendar month, irrespective of the payment dates of family benefits under the legislation, the institution which has paid the family benefits by virtue of the legislation under which they were granted at the beginning of that month, shall continue to do so until the end of the month in progress. What that state then does is Article 59(2), it shall inform the institution of the other member state of the date on which it ceases to pay, and then payment of benefits from the other member state takes effect from that date. Now, I submit that if Judge Jacobs' interpretation of Article 7 is right, this provision is otiose, because it's headed rules applicable where the applicable legislation and or the competence to grant family benefits changes. So it has to be given meaning in a situation where the applicable legislation changes. And the fundamental assumption which underpins it is clearly that the applicable legislation changes, the current state stops paying, and the new state takes over. Doesn't provide any qualification. It doesn't say there needs to be an application. It simply proceeds on the basis that where the applicable legislation changes, the state stops paying at the end of the month.
And this is your part of your construction argument on
Indeed.
ground 1.
Yes. And Judge Jacobs looked at this provision and he said, well, the applicable legislation doesn't change. It didn't change to, he says it in terms, the applicable legislation didn't change, it remained the UK because we had to carry on paying the benefit, and we submit whatever other arguments there might be in this case, that is clearly wrong.
If you look at Title 3.
Yes, and had Judge Jacobs not made that error, that the applicable legislation didn't change, he would resubmit to grapple with Article 59 and the need to reconcile Article 59 with the other provisions.
Yes, I mean, the problem is Article 7, although it's general provisions, you've got to work out what the system does first and then see whether that involves treatment that's contrary to Article 7. And what he's done, he's treated Article 7, you say, as the starting point and ignored everything else afterwards.
Precisely, and that's my point about one can come to this case and cold and think, what's the problem here? It's all Article 7, but it's just not that simple, because one has to look at the language of Article 7, recognise that it itself is capable of more than one construction, and then look at the words which say subject to other provisions of the legislation. In my submission, what the Court of Justice would do if it were faced with this issue is say, okay, Article 7 says that, but there are all these cases that say it's about applicable legislation, and we also need to look at Article 59. And Article 59 makes clear that where there's a change of applicable legislation, that state pays until the end of the month. When I gave my 3 interpretations of Article 7, this is my interpretation number 3. It gives meaning to Article 7 because that state has to pay until the end of the month, regardless of what its domestic legislation says. So it gives meaning to Article 7, but crucially, it also gives proper meaning to Article 59. And Judge Jacobs and the advocate and the respondent do not give meaning to Article 59.
So what I'm reminding myself, the upper tribunal judge said was, when Article 7 applies, as it does here, that legislation, the applicable legislation remains the same, and you say on any view that's fundamentally wrong.
It's fundamentally wrong. It's indefensible in my submission. It's clear from the entire way that we've looked at this legislation that what happens is one always has to know which legislation applies. And I took the court to recital, I think it's 18A, which says just because you're paying a benefit doesn't mean your legislation's applicable.
No, but you are, sorry, the state paying the benefit is then, that is then the state that is competent to grant the benefit.
On a
right?
Tolley analysis, yes.
Well, it is.
exactly.
So, I mean,
Yes.
I mean, 59.1 begins by saying where the applicable legislation and/or the competence to grant family benefits change. So surely on the upper tribunal's analysis, what has changed is, sorry, what has not changed is the competence to grant family benefits dating back to one's residence in the UK.
On what Judge Jacobs says is, well, he doesn't decide it on the basis of competence. He decides it on the basis of
Well,
applicable
that may have been a
legislation.
slip of the pen. I mean, if one substitutes competence for applicable legislation, that then is coherent with what he thought the right construction was, isn't it?
Well, it's not in my submission because the applicable legislation has undoubtedly changed.
Yes, but everyone agrees it's changed for the future. The question is, what is the accrued effect of what's happened in the past?
But there is nothing in this provision that says where the applicable legislation changes, but a state's already paying.
Well, surely the
That state-
and/or allows for a situation where applicable legislation is not in the picture, and it's just a question of competence.
But applicable legislation is in the picture here. There is a change of applicable
Well,
legislation.
sorry, yes, but it's not one which has any effect on his interpretation on the payment of the child benefit.
Well, and in my submission, that's a problem because it's directly contrary to Article
Well, I
59.
don't at the moment see why it's contrary to Article 59, which is very loosely framed, but there's that and/or, and this is, after all, this is an implementing. This is not itself a provision which is intended to lay down substantive rights. It's just a machinery change.
But can I answer that question by giving an example? Because why is it used the word and or the competence? Because as I've submitted,
Goodness, yes.
that one can have two applicable legislations and a state which is competent by way of priority right and another state which isn't, and that's an example where a competence could change, which has nothing to do with applicable legislation. I can probably give another example if I reflect on it, but it's catering for two discrete situations. One where the applicable legislation changes, and it doesn't say where the applicable legislation changes but the competence does not change. It says where the applicable legislation changes, this is what happens. It also deals with a discrete situation, which is where there's no change in applicable legislation but the competence changes.
But it does say and
Or both.
But what my fault? I haven't picked up competence as a concept. What is meant by competence here?
Well, it means different things in different contexts. In an export of sickness benefits situation, it means so the competent state for Mrs. Tolley carried on being the UK,
Yeah.
even though its law wasn't applicable. But if one translates that to this, the competence didn't change. So for Mrs. Tolley,
Well, the competence did change up until the time she got on the plane. The competent and applicable state was the United Kingdom. When she arrived in Spain, under Spanish law, we assume, competence changed because they now had competence to grant it because she now met the requirements of the Spanish legislation, we assume.
I would put that the other way around.
Ah,
What
okay.
happened was that the applicable legislation
changed,
changed,
and
but
the
the
competence-
competence did not change because the UK remained competent
Well,
in respect
But
of that
the
benefit.
competence of Spain changes, what I'm saying. Spain wasn't competent until she arrived in Spain because she didn't meet the requirements of Spanish legislation, we assume. I assume you've got to be resident in Spain.
For Mrs. Tolley.
Yeah, no,
Yes,
no,
but-
for Mrs. Carrington.
Oh, I'm so sorry. I was talking about Mrs. Tolley.
Oh,
So
right.
yes. So for Mrs. Carrington, the applicable legislation undoubtedly changed. The competence to grant family benefits changed. But if Judge Jacobs is right, that the words where the applicable legislation changes could then have just been left out, because when does that bite if not on a change of applicable legislation?
Well, we're dealing here with an article that applies to benefits of all kinds. I mean,
It
No,
doesn't. It applies to family benefits.
sorry, is this specifically a
Yeah,
family
it's
benefit
in the
provision?
heading.
I beg your pardon.
And
Yeah,
that's part of
yeah,
my point.
my
There is
fault.
no
Yes.
equivalent provision for sickness benefits.
yeah.
So this, in my submission, is compelling that the
Yes.
legislature clearly thinks where there's a change of applicable legislation, the state stops paying. And in my submission, there's simply no other. There's no other reasonable interpretation to put on this. If one ignores the words where the competence changes, then no doubt my learned friend will say, well, competence didn't change because we had to keep paying because of Article 7. But the problem is, it has the words in it where the applicable legislation changes.
But what about all and all?
Well,
what about where the competence to grant family benefits changes?
But it applies where the applicable legislation.
No. So take out the applicable legislation and because of the word all. So there is the word all. So it could be simply where the competence to grant family benefits changes. And I still, it's my inadequacy. I don't understand what is meant by competence here. What is meant by competence?
Well, that I will try and give the court an example, but I'm saying actually the primary situation catered for by Article 59 is where the applicable legislation.
I understand. If it says where the applicable legislation and the competence, then it's the problem potentially is the word or, which does envisage one, not both changing, but one or other.
But your case is that the one thing that we know that has happened here is the change in applicable legislation, and that alone, whether or not the competence changes, is enough to trigger the article, is what you're saying. I
Yes,
think.
and that's why I'd rely on the or.
I think that's
Exactly what
Yes.
I'm saying.
But just as a matter of what your position is, did the competence to grant family benefits change in this
Yes,
case?
we submit yes by virtue of the change in applicable legislation. My learned friend says no, because we are still competent, just as the UK was competent for Mrs. Tolley.
Well, in a sense, one keeps on chasing one's tail here. I mean, he says no because effectively he's saying you can carry over your existing child benefit.
Yeah.
On the other hand, it does change in the sense that any future benefits earned by residents in Spain will, of course, involve a change of competence because they'll be payable by Spain instead of England, or instead of the UK.
There is an unavoidable point from Article 59, which is that it says in terms where the applicable legislation and or so one can have a situation where only the applicable legislation changes, it applies. One can have a situation where both happen, it applies, or one can have a situation where only the competence
Yes, but then
changes.
all that the article does is just lay down a provision as to what is to happen during the month of departure, isn't it?
But it presupposes that at the end of that month, the
The
new
new
one is
state,
going to have it.
the new
That's, I think
state.
that's your point, isn't it, Ms. Smith?
Exactly.
Is that it assumes that there will come a time on the first of the next month when the world will have altered and it will no longer be England, it will be Spain.
Because of the change of applicable legislation.
Exactly.
And this is here, it's only sorting out the last few days of October. But the whole thing that you say, as I understand it, it is predicated on, is come November, the world will be different. You'll be getting pesetas, or euros, not pounds, sorry. But that's your point, isn't it?
It's exactly right, because that's what it says
Yeah.
in Article 59 too. It stops paying. It just tells the other state, and then the other state has to pay. It doesn't. It's
You
very
only need a
simple.
mechanism to deal with the period of a few days in a month when you know that from the next month onwards it's going to be different.
Exactly.
Yeah.
And it's the only way in my submission to give those words where the applicable
Meaning.
legislation changes meaning.
Was
Otherwise,
the judge taken to? I mean, he obviously was aware of Article 11. He doesn't refer.
he
to
refers to Article 59, but
it. Doesn't refer to Article 11.
he does refer to it. Oh, he may not have referred
You
to
must
it.
have known Article 11, though, this judge.
No, I mean he's.
No. Okay.
It's certainly a provision he's aware of because it appears in all his judgments
Yes.
about the Tory cases. So it,
I'm not suggesting this experience that a tribunal judge was
no, he's
unaware.
no, he certainly knew. In my submission, he led himself into error by saying the applicable legislation didn't change, but it did.
Yeah.
And so we submit that Article 59 is plain on its face. And if, for example, the person moves on the first, say, that the state has to pay for the rest of that month, regardless of its residence rules, that does give meaning to Article 7. So it's reading Article 7 subject to Article 59, which is exactly what Article 7 tells us, and there is no equivalent provision, I repeat, for sickness benefits. None. And in my submission, that the construction 3 that I advanced gives coherence to reading both of these provisions together.
Well, wait a minute. Article 7 says, unless otherwise provided for by this regulation. But the regulation we're looking at is not this regulation. It's
No,
a different one.
But Article 59 reflects what I've said is the underpinning of Article 67, which is it's determined on the basis of applicable law. And when the court looks at the case law, the court will see that the court doesn't approach it in silos. It does look at this legislation as a coherent whole, as it has to, because otherwise the legislature has sat there and pointlessly prescribed a procedure which will never bite.
But it's not really a situation of subjugating Article 7 to other articles.
No,
It's
really
working out what system applies. You say the applicable law is now Spain, and then working out whether the fact that that applies now means that the United Kingdom is refusing to pay the benefit on account of the residence requirement in section 146, or is it in fact refusing to pay the benefit for a different legal reason, that it's Article 11, whatever it is, 2E of
Yes.
the thing,
Yes,
whatever
exactly
the thing
that.
is.
It's Article 7 applied in context in relation to these specific benefits.
Yeah. So grounds 2 and 3 are in a way illustrative of grounds 1 as well.
I'm so sorry, I didn't.
Grounds 2 and 3 are actually indicative of why you must win, you say, on ground 1 as well, because they're all showing you different ways of how the primary point is the applicable law and the basis for the non-payment is the applicable law, not residence.
Yes, exactly. And because for family benefits, applicable legislation is prime. And for example, see Article 59 and the case law I'm about to take the court to. And it's exactly that. It's yes, Article 7 says what it says, and indeed it can be given meaning. It is being given meaning because the residence condition has to be disapplied that month.
Because if the father moved to Spain to work, leaving Mrs. Carrington and the boy in England, Spain would still be responsible because the father is now working in Spain. The child's residence wouldn't have altered at all, you would say, I imagine, but the applicable law has changed because the parent has now moved into a different category under Article 11.
And then that would be an Article 67 situation. I'm looking behind because that they would Article 67 in the sense that they're not
whichever
residing
one
in
it
the
is,
same
but there'd be
place.
priority rules.
And then Article 68 sorts out the priorities. And,
Yeah.
and I say for a straightforward change of applicable law, there isn't need to worry about priorities. But if I lose
But
on
the key
ground
point
one,
is it shows that it's not the residence, it's happenstance that it is residence here, because that's the thing that they fall into with the applicable law.
yes,
It's the applicable law, it's the legal basis upon which the benefit is now payable,
It's-
you say, I think.
yes, exactly.
If you're right, that is.
Yes. So that's Article 59. Article 60, the procedure for applying Articles 67 and 68. So this is all about sorting out priorities. How does the states go about doing this? And the court will note that it isn't the procedure for applying Article 7 in the context of family benefits. It's only Articles 67 and 68. So what happens, the application is addressed to the competent institution. That has to be read with Article 59 as to what happens when there's a change of applicable law. And then the next bit of Article 61 is dealing with how you work things out in a situation covered by Article 7, where you've got the family in one state and the worker in another. Take a classic example. And then what the court will then see in Article 60, sub 2, sub 3 and sub 4 is how the states go about sorting this out between them. So what happens in Article 62 is the institution to which an application is made examines the application on the basis of the information, taking into account the overall factual and legal situation. Then it has to decide whether its legislation is applicable by priority right. If it appears that there's a differential supplement, if it thinks its legislation is applicable by priority right, it just gets on with paying. It shall provide the family benefits. And then the bottom on page 137, if it appears that there may be entitlement to a differential supplement, so the Spain 300, France 200 example, it has to forward the application to the other state and tell the person, and it also tells the other member state of its decision. So that's where the state concludes that its legislation is applicable by priority right. If it thinks it's not, so it thinks its legislation is applicable but not by priority right, then it takes a provisional decision and it forwards the application to the institution of the other state. And then Article 64 says where there's a difference of views between the institutions, Article 6.2 of the implementing regulation should apply. Now that's, I don't want to overcomplicate things, but Article 6 is all about making provisional payments while you work out who's competent. And that, there was a case in this court about that called Filetia, which we haven't troubled the court with, but I can give the court the reference later. But it's not something that needs to concern the court in this case, but that's how it works. So there's a special procedure to protect the applicant where there's a dispute. And then...
And it's the sort of procedure that you say would have been required in relation to Article 7 if the respondent's construction was right.
Yes, because there's nothing here to deal with it. I mean, given that it constitutes such a fundamental change to the way things have worked, it's somewhat surprising, if it was intended to work as Judge Jacobs decided, that the legislature didn't think, right, okay, we're changing everything now. We're now letting a person keep a family benefit indefinitely. Oh, that could create some practical problems. We better sort that out with some provisions. They're just not here. So what one has to do, if I'm wrong on ground one, is apply them. But in my submission, if one looks at them, it reinforces my case on ground one.
But that's why you're taking us to this procedure, is that right?
I'm taking the court to this procedure, but A, to show the court how it works, B, for that reason, and C, because it's relevant in the background to my ground two. So this is how these things get worked out, basically. But yes, your ladyship is right.
And if I were to go to page 116 and Title 3 in sickness benefits, this is the one that picks up the DLA component. And looking through the headings very quickly, you will say that the implementing regulation works on a totally different basis for that kind of benefit. So even though I've been worried why there's any difference between the two, you would say that inherent in the implementing regulation in the minds of the European authorities was that whatever the rights and wrongs or logic of it, they did proceed on the basis that there was a difference between sickness benefits and family benefits, just as there used to be in the main regulation 1408.
Exactly, because otherwise there would be something like Article 59 in sickness benefits, and there isn't.
Yeah.
And for that reason, my submission is that if this issue were to end up in the ECJ, it would look at it on a holistic basis.
Yeah.
And it would have to give meaning to Article 59. But for the reasons I've submitted, could also give meaning to Article 7. But for sickness benefits, the court would say, well, look, this is how it was under Article 22, and there's nothing which goes against that. So those are the provisions. Alarmingly lost my speaking note. I have it now.
I think you're taking a deep breath before the case law.
Well, at least these are somebody else's words, not mine. So that's a relief. So I'll take this as quickly as I can, but it's important that I take the court to these cases. The court may say, well, why are you taking us to these cases about 1408, given that this is about 883? And my submission, as the court will have picked up, is that they really set the context against which the legislature was making 883.
Yeah.
And given the dramatic change that it makes, in my submission, it reinforces the point that A, the legislature would have heralded this in a recital, and B, it would have set something out to explain how on earth it worked if it all went wrong. So, can I start with FE, which is at tab 7. So the facts are, they begin at page 389. So the facts go on from paragraph 15 to paragraph 22, but if I can précis them, the child was living in Austria with his mother and he was getting an Austrian benefit, his father was in an Austrian prison, but then his father was moved to a German prison, and Austria said, well, we're not paying this benefit anymore because the applicable legislation has changed. The headline point, and I'll take the court to the detail, is that the court said, yes, that's right. Austria doesn't have to pay anymore because the applicable legislation has changed. And it's a striking case because the child was still in Austria, but the dad had been in prison and then moved to a German prison, and that deprived the Austrian child of their family benefit. So just to unpack that, that's the headline. Could I invite the court to look first at paragraph 24? And the court will see that this starts off as a question about EU free movement and discrimination. So,
Sorry, 24 of the judgment of the court.
Page 391.
391, thank you.
Yes, in the judgment, finding however it begins. So that's the question. Is there discrimination? Article 12 EC is what became Article 18, and Article 3 of 1408 is what becomes Article 4 of 883. So what the child is saying is this is discriminatory. You should treat my dad as being in a Austrian prison. So paragraph 26, confirmation that this is a case about family benefits. Paragraphs 34 and 35 in a nutshell is Austria saying, well, our law isn't applicable, so we're not going to pay. And then at that point, the Commission comes up with a bright idea in its submissions. The Commission says, well, how about let's have Austrian law and German law applicable at paragraph 37, and it refers to the old overlapping provisions in that respect. And the court says no. There aren't two applicable legislations. So paragraph 38, in rejecting that argument, it says no. The system is that there's just one applicable law. And then it says it's different where you've got a situation where you've got two spouses working, one in one state, one in the other. That's a classic situation where there's a need for overlapping rules, but they don't apply here. Because the child is just a member of his father's family, so he's regulated by what happens to the father. So that's rejected. And then, crucially, the passage sidelined at paragraphs 43 to 46. I'll invite the court to read that, but what it basically says is no, the change of applicable law definitively resolves this case.
Sorry, I'm being very slow picking up the facts. So this was a case where it was only the father who was employed, is that right?
Yes, he was in prison.
Well, he was in prison and therefore
But
deemed
working.
to be.
But what the court says
Yes.
is we don't care how German legislation has become applicable. We don't care if it's under Article 13(2)(a) because he's a worker or just because he's residing in Germany. That's paragraph 45. The court isn't bothered about how German law became applicable. The fact is that German law did become applicable.
But if it was something like our domestic child benefit, then that would just depend on the fact of being of the parenthood rather than whether one's working or not. But here we're dealing with
it's the supranational question, if you like, versus the national question. And this is a supranational question.
Yeah.
It's about coordination. So the court says because the applicable law has changed, it has changed. See paragraph 45, and because it's changed, Austria is not required to pay anymore, and that's that.
I know. So I'm sorry. What are the nature of the family benefits we're talking about?
I don't know if there's much detail in the judgment about
No,
it, but it is, the point is that it is a family benefit. That's confirmed in the judgment. It was
A monthly advance on
an
maintenance
advance on
payments.
maintenance payments.
Whatever that is, yes.
But certainly we would submit that the rules are the same for all family benefits.
No.
So if this had been a UK case and he'd been transferred from a UK prison to a French prison, the UK child would have lost their entitlement to child benefits.
So sorry, the point that's niggling with me is why are we looking only at the position of the father rather than that of the mother when it's a family benefit we're concerned with?
Because the father is the one who's moved and who's caught by the legislation. I suspect the mother was economically inactive.
Well, then maybe that's
and,
the answer.
There was no cross-border element to her situation. So insofar as the child wants to rely on the legislation, it's only the father who's within scope.
Well, the national law is at page 373 in the Advocate General's opinion, and it does sound very Austrian. AG 10 says that advances on maintenance payments are to be granted to minor children if the parent liable to provide maintenance
I see.
fails to meet his maintenance obligation. And implicit in that is that it's the father, not the mother, in Austrian law at that stage. Don't forget, this is a long time ago.
Yes, sounds a bit outdated, but of course this
Yeah.
was 2005, yes.
But we would submit that the fundamental point in terms of social security coordination is that the court says the applicable law has changed, the child loses the
Yes.
benefit.
Well, I suppose in a way that's the point that matters rather than what,
Yes.
what it was that brought that about.
Yes, that's my submission. And the court doesn't care, in effect, whether it changes because he's working in Germany or he's not working, he's just become resident there. They say either way the applicable law's changed, and I'm afraid that's the end. And then for the court's note, paragraphs 48 to 51 deal with an argument that there was discrimination.
I've just found AG 25376. Nothing is known about the situation of the mother in this case. It must therefore be examined whether the father can be regarded as employed.
And it,
So it may have been hypothetical. She may have been working in the Austrian equivalent of suffragists, for all we know.
yes, and often these cases proceed on a very specific factual basis. But
Yeah.
there's no suggestion, I think, of a cross-border element. But in any event, it doesn't matter for my purposes.
On the facts and on the law, they proceeded on the basis that the key question under national law was where was the father? And the answer was when he was in prison in Germany doing compulsory labour, he was in Germany, and that was the end of it.
Yeah, which law applied to him? It was German law, so that's it. Austria can stop paying.
Yeah.
And the discrimination argument is dealt with at paragraph 48 to 52, and also in the dispositif at the end. I mean, the court was essentially saying that arguments about free movement and discrimination can't undo the inexorable result of a change of applicable law. That's it in a nutshell.
Yes.
Because that was the question that was referred. It was all about discrimination, but of course the court doesn't deal with it as discrimination. It actually says, well, hold on a minute, let's look and see what the applicable law is. That resolves the issues.
And the applicable law will almost by definition be residence-based in one way or another, depending on the country concerned.
Yes, the father his applicable law either changed because he started working in Austria,
Yes.
which is now Article 11.2a, or because he became resident there. But the
Yes.
court doesn't care about that. It just says that's the applicable
I mean,
law.
this was a bit like the point you were telling us about earlier in the Commission and the United Kingdom case, wasn't it, where the arguments that there was unlawful discrimination on the ground of residence was rejected because it was just part of a national legislation.
Yes, although in this case it's because of the supranational rules in terms of it being the coordination rules, whereas in Commission and UK it turned on there was no argument in Commission and UK about applicable law and competence. It was just because the UK accepted in the relevant cases it was competent, but it said we're competent, we can make you have a right to reside before we pay you, and the court says okay, fine.
Yes.
Whereas this one proceeds at the top level rather than the second level in terms of saying, well, Austrian law just doesn't apply.
I mean, I suppose one reason this leaves me initial pause for thought is I'm so used to residence being a sort of forbidden discriminatory factor in the context of EU law, in relation to fundamental freedoms and so forth. It's at first sight startling to find the European Court saying residence is absolutely fine as a discriminatory factor.
And that's because because the court isn't looking at residence, it's looking at the change of applicable law, because this is a coordinating provision, a conflict of law provision.
And this is national unharmonised legislation.
Exactly, yeah. So the court doesn't have to worry about, it's not concerned with discrimination. It basically says, well, Austria's, we don't get into that because Austria's entitled to stop paying, because under the conflict of law rules, which one examines first, Austria's not required to pay.
Well, I suppose it could arise in a way in which it has in different tax contexts, based on an argument that the whole legislative system was unlawful because it prevented or impeded free movement. I mean, that's not the basis on which it's ever been argued or put.
In terms of the provisions themselves.
I mean, the actual provisions themselves. I'm
coordinating-
thinking of all the FII legislation, all that kind of stuff, which is
Yes,
the
and
kind
so-
of context where residence, of course, is absolutely a typical example of a factor that
But
gives
here-
rise to untold problems.
Because here it is about working out, well, it's a conflict of law provision, which state's law applies. So that's the way. There were, I read, I think, in Pennings, that at the time 883 was negotiated, some people were saying, well, let's just make the whole thing residence-based. Let's just make the state of residence responsible. And that's not the solution that's been adopted. It's the way that it is in Article 11.3a. So the primary rule is state of work, but if there isn't a state of work, then it's the state of residence which becomes competent, whose legislation becomes applicable, with the result for family benefits that the first state stops paying.
And
As
you
that.
say that follows clearly in terms of thinking a result from the wording of 52 in the dispositif, because the way they put it at the bottom is neither the provisions of that regulation, particularly but not limited to Article 3, nor Article 12, preclude in such a situation the legislation of a member state from making the grant of a family benefit condition on subject to the condition that he remains a prisoner in that state, i.e. that he's residing, albeit unwillingly, in Austria. And you say that's the way they put it, is the discrimination provisions of the regulation just doesn't preclude a member state. It doesn't stop a member state having the freedom to say, well, I'm sorry, mate, if you've opted to transfer back to back to Germany, it's their problem now.
Yeah, we're not responsible
Yeah.
for you anymore. That's exactly how it works, and that operates at the top level. And we'll see in the cases that we're coming to that strikingly, it's not just that states aren't that they can refuse to pay. In fact, they're precluded from paying. And I'll take the call to that case in a minute. But not only in some circumstances, you're simply not allowed to pay family benefits if you're not the state of applicable legislation. So there are 4 cases in that respect that I'll take the court to. So there's the case of Bosman, there's the case of Kuczynski, which is Bosman 2, and then there is a case called B, which I will also take the court to, and particularly B, I'd submit, is striking on its facts, because the court says, sorry, Czech Republic, you were never allowed to pay this benefit, you shouldn't have been doing it. So can I start with Bosman at tab 8, and the facts, again, we can take them from the judgment at paragraphs 9 and 10. So Mrs. Bosman was residing in Germany and bringing up her children there, but she was working in the Netherlands. So that makes Netherlands law applicable. So under German domestic law, she's entitled to benefits, but Germany stops paying when Dutch law becomes applicable. Now, the difference here, and the crucial difference with this case and our case, is that she carried on being resident in the old state whose law used to be applicable, and the court describes that, as we'll see, as a close connecting factor. So paragraph 18 describes the old Article 73, and I've already submitted it's the same as Article 67. So the first thing the court does is look at, well, what's the applicable legislation, and it concludes that the applicable legislation is that of the Netherlands. paragraph 19. And then at paragraphs 20 to 25, it again concludes that this isn't a situation where rules about overlapping apply. And it's complicated because it's based on the old priority rules, which are even more complicated than the ones in 883. But basically, the court says at paragraph 25 that there's no overlapping because the right to child benefit in the member state of employment, which is the Netherlands, is excluded because of the age of the children. So Mrs. Bosman's problem was that although she was subject to the law of the Netherlands, they didn't pay because her children were too old.
Exactly.
So paragraph 27 is the key point. It follows that community law does not require the competent German authorities to grant Mrs. Bosman the family benefit, and that's because its law is not applicable. Then it gets a bit more complicated because what the court goes on to decide is, despite not being required to pay, can Germany be permitted to pay? And it says, yes, Germany can be permitted to pay. And essentially, and as the later courts explain this judgment, it's because there is a close connecting factor of residence. But the crucial point in this case, from my perspective, is that Germany is not required to pay because it is not the state applicable law.
Sorry, which is the paragraph where we find the connecting factor of residence making all the difference?
It's more clear from later cases which consider this case.
I see.
But they've got to find a way of explaining that conclusion.
Yes, exactly. I mean,
you say the other cases make it clear that you're not even allowed.
Exactly. So there are three real cases. The next case we're going to is B, which is a case where the state wasn't allowed because the person wasn't living in the state that was trying to pay. We have Bosman that we've just looked at, where the person was resident still in the paying state, and there's a case called Hudzinski where the people had paid income tax. So the court says, well, that's also another close connecting factor, and all of these cases have been analysed by Judge Jacobs in a decision that I've given a reference for in my skeleton and is in the authorities bundle. And he says, well, what one's doing is looking for certain types of close connecting factors. So to contrast Bosman where it was allowed with B where it wasn't, and B is an 883 case. So B is at tab 14, and note that this is a case where the court didn't even feel it needed to hear from the Advocate General. So we don't have an Advocate General's opinion. The first, it is a case about family benefits. So paragraph 2 of the judgment, page 646. What we see is that the Czech Republic was paying benefits to Mrs. B, but it withdrew that entitlement because it said it wasn't competent, and we'll see why it said that. So, paragraph 11 will see that under Czech law, anyone who was registered as permanently resident in Czech territory could claim the family benefit, which was called Parental Allowance. So that's the domestic law. And then the facts are at paragraphs 11 to 14. So the family is resident in France, but it's registered as permanent residents of the Czech Republic, so qualifies for these family benefits under Czech law. So that's in paragraphs 12 to 14, and paragraph 14, we can see that the benefit was granted in 2009, but the Czech Republic thinks now that 883's come in, it's got to stop paying. It isn't clear why they took that view, but they stopped paying because they thought 883 meant that they were required to stop paying. So the court...
Well, they said they thought they were no longer the competent member state.
Yes, under because the centre of interest of Mrs. B. I mean, the court doesn't see any difference here between 1408 and 883, as we'll see. It says, well, it was never allowed to pay. So the issue is captured in paragraph 22. Is a member state precluded from being regarded as the competent state for granting a family benefit on the ground that the person's permanently resident there but doesn't actually live or work there? So that's the question, and the court, again, crucially, how does it answer that question? It starts by looking at Title 2. What's the applicable legislation? That's what will help us sort this out. So it goes through the language that's seen in all the cases. The whole point of this is just so that there's one applicable legislation. And then it says the legislation applicable to her under 1408 is the legislation of France. So the applicable legislation, France, paragraph 25. And then there's a crucial passage at 26 to 30, and I'll shut up for a welcome moment and invite the court to read paragraphs 26 to 30, if I may.
Of course. Yeah.
So the central principle I derive from that case is that a state whose law is not applicable is not allowed to pay unless there are specific and close connecting factors. We know on the facts of Bosman that residence was good enough, but in this case, simply being registered as a permanent resident was not good enough, with the outcome that the Czech Republic was precluded from paying and should never have been paying at all, even under 1408.
I mean, to really understand what's going on here, one would need, I suppose, a bit more information about what being registered as permanently resident really meant and what the qualifications for it were. And at first blush, it's rather hard to see how you can properly be so registered if you're habitually resident in a different country.
Paragraph 12 of the judgment, they each had a home there,
Well,
and they'd registered that address, which is how under Czech law they came to be.
yeah. Anyway, I mean, it's obviously it shows a degree of long-term connection with the Czech Republic, which is still being retained,
But it wasn't good enough.
but not good enough in this context.
From your point of view, though, you don't need to show that England couldn't pay Mrs. Carrington the money.
No.
No,
All you
quite.
need to show is that they were not obliged to.
Yes.
And that does not involve a breach of Article 7.
But the reason I take the court to this case is to
Yes.
show how far that
How strong the
extends.
principle is.
Yes.
Yes, how important the principle is, and this is a case because we've seen that the court stopped paying because of 883. We now know, sorry, the Czech Republic stopped paying because of 883. We now know it should never have been paying under 1408, but the court goes on to deal with, under question 3, with what is the position under 883. And again, I rely on this passage. Paragraph 33, the court does the same thing here. It says, under Article 11.3, and for reasons similar to those given in paragraph 24 to 26, she remains subject to the legislation of the member state of residence. So, France, she's subject to the legislation of France. And then paragraphs 35 and 36, Regulation 883 did not introduce any relevant change in relation to 1408/71 insofar as concerns the provisions governing the designation of the competent member state or the concept of residence, which are central to the outcome of the case before the National Court. The Czech Republic is not, therefore, the competent state in the present case, and this was a case where it had been paying benefit and stopped, so at some point Mrs B had a benefit from the Czech Republic, and then crucially paragraph 36, Article 11 precludes a member state from being regarded as the competent state for the purpose of granting a family benefit on the sole ground that the person concerned is registered as being permanently resident in its territory, where neither that person nor the members of his family work or habitually reside in that member state. So the law isn't applicable, there's no close connecting factor. Not only are you not required to pay, but you are precluded from paying. And this is a case about 883, so the principle in my submission carries across to 883. Now I accept that the court didn't consider Article 7, but it would in my submission be somewhat odd if this case could simply be ignored, and of course Mrs B was in receipt of a benefit and it was stopped. The difference in her case is that she hadn't previously lived in the Czech Republic. On the other hand, she has an enduring connection in the sense that she still has homes registered there. And yet the court says, no, not only not required to pay, can't pay. And if Judge Jacobs is right, that in my submission sits, to put the respondent's case at best, very unhappily with this case. But in my submission, it makes clear that when one does what I invite the court to do, is to take a step back, look at everything together, my case on ground 1 is clearly right.
So could the United Kingdom, was it wrong to have paid the money to Mrs. Carrington?
If it is, we've said that we're going to pay. I mean, I don't have to go that far, as your lordship observed, because it's
She's got no connection with this country as far as we know on the facts available. She's left the country.
she's left, yes. So, but HMRC's point is certainly that we're not required to pay. But your lordship is quite right. An issue could indeed arise as to whether Article 7 is making member states pay when they shouldn't be. Because on my extreme example, if someone has a child here and then leaves when the child is 6 months and they never come back and they move to France, but they're fixed with their entitlement because of Article 7, that there's no connection.
The only reason I ask is it would be a different way of putting your case, because the factor which prevents her getting money now is not the applicable law, but the fact that the United Kingdom doesn't even have power to pay her. So you don't even have to read section 146.
Yes, but we haven't gone that far,
Haven't
because
gone
we
that
say
far.
it's sorted out by applicable legislation, and it would be an interesting point as to whether not only are you not required to pay, might the UK also be precluded from paying, and might other states, if my learned friend's case is right, as I say, when somebody comes here, HMRC will say, you're not paying. You can make your previous state carry on paying. Are those states also paying when they shouldn't be? Certainly on this authority, yes. And that's why I submit that this is a major piece of the jigsaw. So when one takes a step back and looks at everything in the round, it's quite clear that the meaning I've given to Article 7 is the right one, and to suggest it has that much more dramatic meaning in my submission is wrong. So the other case, the court will have seen a reference to Hudzinski in the case that we've just read. This is also a complicated case, as they all are. In this case, it's different again. It's about seasonal workers.
Is this, sorry, before we get, is this a case in the bundle?
It is. It's at tab 13.
So I just want to get the name right. So I try writing it down.
Yes, tab 13.
It's not.
This is what you call Bosman 2?
Yes, it is. It's in the extract from Pennings that the court has. I think Pennings says we're waiting to see. Actually, I think it's something in Pennings that the court doesn't have. At that time, people were waiting to see how far the Hudzinski principle went. So this addresses Bosman, but in a different situation. So these were seasonal workers who've been subject to income tax in Germany, but because of the way the rules worked, they stayed subject to Polish law. So that...
Sorry, stayed subject to...
Polish law. So they just worked in Germany for short periods. See paragraphs 14 to 20. They paid income tax in Germany. But Germany basically said, well, we don't care if you paid income tax here, we're not going to give you benefit because our law isn't applicable. And the argument that was advanced by the two workers in that case is captured in the Advocate General's opinion at paragraph 36, which is on page 620. They say that, yes, okay, the applicable legislation didn't change, we remain subject to Polish law, but if we were entitled under German law, we can still receive the benefits. So how did the court deal with this? There's a long sideline passage at paragraphs 39 to 50 where the court repeats essentially what it says in Bosman, which is not required to pay but not precluded from paying. And then paragraph 55 to 56, the court says that although Germany's not required to pay, a state can't be prohibited from paying if, and this is paragraph 56, the person's entitled in effect under domestic legislation. So under the normal conditions of German legislation, they
Sorry,
were...
I haven't got that. What page is that?
I'm so sorry,
That's
it's
my fault.
639. Paragraph 55 and 56. What the court is saying, well, okay, Germany isn't required to pay, but actually it shouldn't be precluded from paying in a situation where the person's entitled under German domestic law. And for the court's note, the relevant provisions in German law are at paragraphs 11 and 12 on page 633. Under German domestic law, somebody who was subject to unlimited income tax liability would be entitled to child benefit, other than a strange wrinkle in German law, which is described at paragraph 12 that I'll come on to in a moment, because it makes this case a bit more complicated. But the important point is they worked in Germany, they paid taxes there, and yet they couldn't get the German benefit. And so we've seen the court says, well, Germany is not required to pay, But it then goes on to say that Germany is allowed to pay, and it's paragraph 60 to 62 which are key in that respect, because the court says that there's a connecting factor present in this case, so different from Bosman, it's not residence, but it's being subject to unlimited income tax liability. And what the court's saying in 62 is the Bosman principle doesn't just apply where there's residence as a close connecting factor, it also applies where there's some other close connecting factor, here the payment of income tax. And then at paragraph 66, the court says such connection is based on a precise criterion and may be regarded as being sufficiently close when account is also taken of the fact that the family benefit claimed is financed by tax revenue, because of course these individuals paid tax to Germany. And then, in a fairly complex discussion at paragraph 69 onwards, which needn't detain us too long, the court deals with the fact that German law also provided that even if you pay income tax, if you're not subject to German law, we're not going to pay you. And what the court says in a nutshell is that if Germany is going to include that kind of an overlapping rule in its domestic legislation, it needs to comply with EU law. And on these facts, it didn't comply with EU law. So one ends up in a situation where Germany wasn't required to pay, but it made provision in its national law, and the individuals concerned got the benefit of that national law. So that is yet again another case where not required to pay, but a specific close connecting factor, which is here income tax. And the judgment is basically saying it's not just residence. Here's another close connecting factor, which is payment of income tax. So all of these cases effectively are saying family benefits, if your legislation isn't applicable, you haven't got to pay them. There's one final case to mention, which I included when the respondent was in person, in case there was a point that she wanted to make on it, and it's the case of Kusi-Jarvi, which is at tab 6. I don't know if my learned friend's going to make submissions on it. He may well be, in which case I'll address it in reply. But I just draw the court's attention to this judgment. It's a puzzling judgment in many respects, but it's a case where the Advocate General dealt with the issues as if it was a sickness benefit, and then the court dealt with the issues and said the benefits of family benefits. So there's no analysis from the Advocate General which can shed any light on what the court says, because it basically decides things for itself. And this is a case where the facts are that Mrs. Kusi-Jarvi judgment, paragraph 2 to 4, so she works in Sweden, paragraph 3, then she gets unemployment benefit, and then she gets the child allowance. And that's described in paragraph 3 as a parental benefit, but it's only payable if the person has been registered as an insured person for at least 180 consecutive days prior to the commencement of payment of the benefit. So this case is about when she moves to Finland, can she keep the benefit, the family benefit? And the Advocate General says yes, but because it's a sickness benefit. So Article 22. The court says, no, it's not, it's a family benefit, but she can't take it with her because that's not what the legislation provides. But the reason I draw this to the court's attention is that there's a paragraph in paragraph 72 where the court references the old version of Article 7. So this is page 364. It says, well, there is Article 10, but that doesn't apply to family benefits.
But at the time, it wasn't. I mean, the language clearly
Exactly.
was now, the language would appear to include it.
But of course, the court, it's not clear if the court's saying, and if it did apply, that would sort out this case, or on what basis. And of course, the court hasn't looked at any case law about family benefits because we don't have an Advocate General opinion. So it's not really clear what the court's saying. It's a remark which is without context or explanation. A key point I should make on this case is that there's a question as to whether this lady would now be covered by Article 11.2 because she was receiving a benefit which was paid on the basis of employed activity. But there is so much unknown on this case that I say it really doesn't take things any further forward, and the cases on family benefits to which I've taken the court really do, in my submission, address my case on ground one. The welcome sound of pages of my speaking note turning. So that in my submission is the essential context, that the pieces of the jigsaw, and I say powerful pieces of the jigsaw. So with that in mind, I can turn to my submissions, which is the final part, on ground one and then grounds 2 and 3.
Thank you.
So drawing all of those strands together, HMRC submits that its position is correct on a textual analysis. It's clearly an interpretation of Article 7 which can apply in the context of family benefits. On a contextual analysis, so in other words, taking into account the other provisions of the regulation and also the provisions of the implementing regulations, and also on a purposive approach. And we submit that the interpretation we advance is consistent with the case law, and it's the only interpretation which gives meaning to all of the provisions. It gives meaning to Article 7, but it also gives meaning to Article 59 of the implementing legislation. And it also clearly respects the principle in the case law that for family benefits, you are not required to pay if you are not the state of applicable legislation.
Just pause, sorry.
Yeah.
If it saves your lordships and your ladyships' pen, that is really captured in paragraph 30 of our reply, where I say drawing all the strands together. it's in the core bundle, the reply at 148.
I think I may have left it in my room, but never mind. I mean,
Probably where it belongs, my lord.
I know. Yes, I probably have. Never. I've got the note, so that's
No,
fine.
your lordship will read it with great interest later. It's paragraph 30 where I draw the
Yes,
strands
and I
together.
remember. I remember exactly where the paragraph comes, and it's helpful to know that I'll find a resume there.
I'm grateful. So that's the drawing the strands together. I'm just going to break the points down a little, if I may. So I mentioned earlier that the predecessor to Article 7 was Article 10 of 1408, and my Lord Justice Lewis has drawn attention to that provision. And I mentioned the case of Stewart, which is a case about the predecessor provision. And that I want to show that case because it shows how broadly the protection of what was Article 10 can be. And my understanding is that in Stewart there was no issue about the UK legislation being applicable. What happened, without spending a long time in this judgment, is that Lucy Stewart moved state to Spain, I think, with her parents, and then when she was there, she made a new claim for, I think, an invalidity benefit.
It's tab 12.
It's at tab 12, yes. Yes, it was a claim for short-term incapacity benefit in youth, which the court decided was an invalidity benefit. So it was one of those benefits where Article 10 applied. And the UK argued in that case. Well, it can protect you if you've already got a benefit when you leave. What it can't do is allow you to claim a new benefit. And the court, in a passage that I've sidelined at paragraphs 59 onwards, said no, that's wrong. And the key passage is paragraph 61, that Article 10 doesn't just protect you if you've got a benefit already, but also that the acquisition of such entitlement may not be refused. Now, as I say, that there wasn't an issue in this case about the UK legislation being applicable, so it's different from our case, but I bring it to the court's attention because it's a key case on the predecessor provision that the court might want to see.
Was this a sickness benefit?
It was an invalidity benefit.
Oh,
So
so
it's
it was
different
called.
again.
Hang on. So, what does Article 10 apply to them or not? I
Yes,
can't-
it does.
It did.
It did. It's
So once you held it was within Article 10, then Article 22 effectively provided for its continuation despite the move to Spain. So,
it wasn't it's a separate type of benefit again. It's what's called an invalidity benefit, which is again a discrete category of benefit. Here it was called incapacity benefit in youth. I'm not sure it exists anymore.
yes, but I'm sorry, Article 22, is that specifically...
That's just about sickness.
Oh, that's just
Yeah,
sickness
this is
benefits in
validity.
the strict sense.
It
I see.
appears that's why what we submit is that Tolly is all about Article 22, and Article 22 is only about sickness
But
benefits.
logically, shouldn't the court have said, I'm so sorry, shouldn't the court have said, although none of you have raised this, the applicable law is actually Spain, and she's not entitled to it?
Well, it wasn't. There was no issue in the case, as I understand. There was no issue in the case because for various complicated reasons to do with benefits that people were already receiving. Stewart, the UK, didn't argue that its legislation wasn't applicable. It accepted that it was. Because if that had been an issue, that the case might have been different. But what the UK was saying is, well, we don't care if our legislation's applicable. Article 10 only stops us taking something away. It doesn't let you claim something new once you've moved.
But logically, it should have said both. It should have said it doesn't apply, but in any event, it's not the applicable legislation. But it wasn't argued, and
it wasn't an issue in the case, and it may be. I mean, certainly the court will have seen that for family benefits, it's the first thing that the court deals with because it is so central.
And as a reference, presumably, so the European Court has to work on the questions that are asked, or they
Yes.
can draw attention to other matters.
Yes, but here there were a lot of issues. The central point in this case was really about the legality of the past presence test, which again doesn't need to detain us now. But
Well, there may have been all sorts of tactical reasons, I suppose, for limiting the scope of the reference to the questions for which, for whatever the reason, the authorities wanted an answer at that point.
yes, the point is that certainly my clear understanding of this case and the reference is that there was no issue about applicable law, and one would have expected the UK to take that point
Yes.
as a primary point if there had been. So that's Stuart, and then really I'm just going to remind the court of points I've already made and not repeat them. I say that Article 7, as I've submitted, has to be looked at with all the other bits and pieces as a coherent whole. I've already taken the court to Article 67 and its predecessor, Article 73, and we submit that Article 73, which the court tells us in Moser is the same as Article 7, is using the language of applicable legislation, and it's reflecting that case law that I've taken the court to, which basically says family benefits turn on applicable legislation. So Article 67, we say, supports our case, and then Article 59. I've made my submissions there. I understand that my learned friend says, well, yeah, maybe, but Article 59 won't bite unless there's an application. I'll address that in reply if I need to, but I say Article 59 is clear. It doesn't say anything about applications. It's very clear. Stop paying, and in fact you're not required to pay if you're not the state of applicable law. See the case law. Then I've dealt with some of the arguments advanced against me in the reply, and I won't repeat those arguments. I'll just flag for the court where they are. So the argument is advanced by the advocate and the respondent that their analysis protects the right to free movement. I've addressed that in paragraphs 24 and 25 of the reply. The points in a nutshell are that the point of the coordinating legislation and the way it protects free movement is not to insulate somebody from the disadvantage of a move, but rather to ensure that they're not left without cover. And we addressed that issue very early in the court's questions to me this morning. That the second point I made in the reply about the free movement argument is that where both the advocate and the respondent rely on recital 13, but recital 13 has to be read with recital 14, which tells you how the objective of protecting acquired rights is to be achieved, and it doesn't mention Article 7. And then I made a general point again, which came out in discussions earlier, and I won't repeat it, but just because this individual wanted to keep the benefit when she moved does not mean that her construction of Article 7 advances free movement rights, and in my submission it doesn't. It works against them. If somebody is simply fixed with the benefit by Article 7, they might be stuck with a benefit which is no good for them. They might not want it. If the submission is, well, the person can just make an application if they want to, that fundamentally undermines the principle that this is a system of coordination. The person can't elect to remove themselves from it. So that's addressed in paragraphs 24 and 25 of the reply, and it has to be, it will also affect incomers. So as I submitted earlier, somebody coming here is then stuck with their old benefit. They might not want it. So it does not, in my submission, it doesn't, one can't advance those arguments about free movement in principle, but even if one can, they don't work. They don't take things any further forward. And then the other point which is taken against me is that it would all be different if this applicant made an application. That's paragraph 23 and 28 of my reply. And again, I've addressed that. It's not what Article 59 says. If that was what was intended, Article 59 could address it, and it would have addressed it in my submission, because it would be very messy if it hadn't. So that's there in the reply, paragraphs 23 to 28, essentially. A point just to make in response to the advocate who says, well, it would just be simple to let the UK pay because they're already paying DLA. Well, the answer to that is there's nothing unusual under this legislation about having different states responsible for different benefits. And in fact, for the reasons I've already submitted, it wouldn't lead to simplicity. It would be a recipe for confusion, because what if the person doesn't want that benefit? What if they move several times? What if they have more children? So it doesn't create simplicity. In fact, it creates a whole set of new problems. Simplicity comes from the rules on applicable law and the way that the court has interpreted those. So for those reasons, I invite the court to accept my submissions on ground 1. And that may be a convenient point to deal with Polly and the reason why I submit that a different approach should be taken for sickness benefits, although I suspect that many of my points have come out of the submissions I've already made.
Yes, thank you.
So Tolly is at tab 17. I'm mindful that the court's well aware of the facts, but for the court's note, they're at paragraphs 18 to 21. Essentially, she was receiving DLA and she moved to Spain. The key passage in the judgment is about the meaning of competent institution, but crucially, it's about the meaning of competent institution for the purposes of Article 22 of 1408, which is just a provision about sickness benefits. And the relevant passage of the judgment begins at paragraph 73, and it goes on to paragraph 85. So what the court says at paragraph 82 is if one looks at the definition of competent state, it means the state where the person is insured at the time of the application for benefit. And that's the point that's taken against me. That's what it must mean, says my learned friend, in Article 67. But the answer to that, as I've shown, I hope, the court, is that Article 67 doesn't talk about competent state. When one looks at it with its predecessor, Article 73, it's talking about applicable legislation. So the analysis in Tolly, which is about Article 22 on the meaning of competent state, cannot be read across to Article 67, which is a completely different type of benefit. And at no stage does the court suggest it's dealing with anything other than sickness benefits. It doesn't mention other benefits. It's focused on provisions which only apply to sickness benefits. And similarly, could I invite the court then to turn up paragraphs 106 and 107 of the Advocate General's opinion on page 728.
So can I just get tolerant? The first part of it doesn't answer the question of whether or not United Kingdom legislation remained applicable legislation for Mrs. Tolley. It left that question open.
Yes.
And then it went on and said this is all about Article 22.
Yes.
And it's because 22(1)(b) specifically talked about people being able to move, unless there was a health reason why they couldn't move, that to have a residence requirement in the context of Article 22 ran counter to Article 22. Is that right?
Yes.
So it never got into Article 10, and it couldn't have got into Article 10, could it, because it didn't apply?
Exactly.
Yeah,
And
okay.
it,
So does it help us then?
well,
Sorry.
I submit it doesn't,
Oh.
but it's relied on. It's
Oh,
relied on
right,
against me, and I
sorry.
have to deal with it to deal with the court's
Yeah.
concern about sickness benefits. In terms of your lordship's question about applicable law, what judge the UK argued in Tolley, one of its arguments was that, well, the applicable law changes, so that's that, and the court says, well, it may or may not have done. We don't care because she's entitled under Article 22, and we'll interpret competent institution in Article 22 with the effect that it's the state that was competent at the time of granting benefit. And of course, if that's a benefit which you've got and you're taking with you, then it would be interpreted in that way. The court discusses another provision to do with sickness benefits, which is Article 19, and that's all about moving to a state and making a new claim rather than taking one with you. So I submit it doesn't help, but I just want to draw the court's attention to the Advocate General, because I've submitted this is all a case about sickness benefits, but there is a footnote which tends to suggest that the Advocate General is alive at least to the difference. So paragraph 106, that the Advocate General, page 728, says retention of entitlement to a cash sickness benefit corresponds to the situation which now prevails, and then he says that there isn't a specific provision comparable to Article 22. On the other hand, it contains in Article 7 a provision on the waiving of residence rules, which covers all social security cash benefits and no longer those listed in Article 10. So what he's saying is, for sickness benefits, it's sorted out by Article 7. Pausing there, just so that the court is aware of how this developed, that originally the Secretary of State for Work and Pensions was arguing that Tolley just didn't apply post 883, and then through a long process, because as the court can imagine this is incredibly difficult, the Secretary of State conceded that there was an ability to take a benefit with you under 883, but the precise legal mechanism when these cases were before Judge Jacobs still has to be thought through. And the court has, in the supplementary bundle, the submissions that we filed before Judge Jacobs when I was led by Mr. Fachenna in relation to how it might work, because at that point the department was saying, well, it's Article 7, but it may be subject to Article 21. The point in a nutshell is that the Secretary of State for Work and Pensions had to grapple with how Tolley applies in an 883 world, and the interpretation which was settled on, supported by what the Advocate General says, is, well, Article 7 is the provision which permits somebody to continue to take the benefit with them. The difference with family benefits, of course, is that A, there's no Tolley, there's no case which says that was the provision, that was the position. On the contrary, there's a whole line of case law which says actually family benefits turn on applicable law. But crucially, as I've submitted, the language of the legislation is different for family benefits. So I won't repeat those submissions I've already made. The footnote is paragraph 107 that the Advocate General, references the case of Kusi Jarvi. He says, well, that case is all about family benefits, it's not about sickness benefits. And then he says, but those provisions on family benefits don't concern the maintenance of a benefit which the worker began to receive before transferring his residence. And then if the court turns to footnote 22, it's a jigsaw puzzle with a lot of pieces, including footnotes. At footnote 22, the Advocate General says, furthermore, Article 73 of Regulation 1408/71 refers not to the competent state, but to the member state whose legislation the worker is subject. So insofar as this case deals with family benefits at all, the Advocate General is saying, well, it's different. You can't, in effect, you can't look at what I've said about competent state and apply that to family benefits, because family benefits refers to the member state to whose legislation the worker is subject. And as I've explained, when either the court or the legislature refers to being subject to the legislation, that is the language of applicable law. So the Advocate General in that footnote is saying, well, with family benefits it's different, turns on applicable legislation. So that is Tolly. Why is the position different for sickness benefits? 3 reasons. First, the construction of the legislation, and I've made those submissions, I won't repeat them. The sickness benefits, there's no provision like Article 67 of Article 59. Second, the history and the case law, because for sickness benefits, we can see that there was a right to export the benefit for an economically inactive individual to take the benefit with them. So the result under 883, Article 7, for sickness benefits reflects the position under 1408. As I've shown the court, for family benefits, it's actually a radical departure from jurisprudence of the court, which says not only are you not required to pay, but you can't pay. And the third is really to reflect the debate earlier that yes, family benefits and sickness benefits could be said to be similar in some respects, but in my submission, if one looks at them in the round, they are fundamentally different. So the comment that the Advocate General makes in Tolly at paragraph 115 is essentially that the new state of residence shouldn't be fixed with the cost of paying sickness benefits to somebody who's already got them before they go. Now, the same logic does not apply to family benefits because they are paid over a long period of time for the lifetime of a child or children, and very many people have children. And if Judge Jacobs' analysis is right, despite somebody moving to the new state and working, which will be very common when family benefits are claimed, the state of work has nothing to do with family benefits, and we submit that given that family benefits are a very common benefit, and given that Judge Jacobs' decision must have the same result in a case where somebody works in a new state, we say that's a further reason for distinguishing sickness benefits and family benefits. But my primary point is fundamentally that the construction of the legislation is an obvious reason for the difference. So that's
the end of ground one, isn't it?
That's my ground one, and,
Yes.
and if grounds 2 and 3 are much shorter, the court will be pleased to hear. Essentially, on ground 1, if I just take the court back to Judge Jacobs' decision, Core Bundle 36.
Round 2.
Ground 1, just to wrap it up. It's,
Right.
But we can keep it open for ground 2 as well. So it's page 38 of the bundle. Paragraph. Paragraph 10, I submit that there is an unanswerable point, that there's an error here, because at the bottom of paragraph 10, Judge Jacobs looks at Article 59 and says the simple answer to the argument is that Article 59 only applies when the legislation changes. When Article 7 applies as it does here, that legislation remains the same. For the reasons I've submitted, that's plainly wrong, and that in my submission, that's a clear error of law. Question for the court is whether I'm right on the rest of it, whether it's a material error. So ground 2 is about Article 68. Now, I should just check, is the court happy for me to continue?
The answer is we can't sit beyond 415, which is impending, So can I ask you this? How are you getting on? I mean, you won't be very much longer, I
No, I
imagine,
won't.
with your two...
But I think 4:15 would be tight because I have to take
Yes.
the court to Schwemmer.
Well, what I'm really going to say is it would be sensible to break off now, provided there will be plenty of time tomorrow for you, obviously, for you to finish. Much more importantly, for Mr. Abduslazi to have plenty of time to put his side of the case to us. So may I just ask if that would be, if, say, there's another half hour at the most, would that be for you to...
I hope so. 45 minutes
Well,
at the max.
That should be comfortable in allowing time for reply.
Yes, well, if you're comfortable with that, I think, I mean, it's been a long and very detailed day, so I think rather than ask you to struggle on for another I don't mean struggle in any adverse sense, but carry on for another 5 minutes of your admirably clear and helpful submissions. It probably would be better if we called it a day, since we can't anyway sit beyond 4:15.
Indeed, I'm most grateful to the court and for the patience in the very slow and painstaking way I've needed
No,
to take the court
absolutely
through matters.
nothing to apologise for. I mean, it's been very necessary, I think, to go through it slowly and carefully as you have. So it's been great assistance to us. But of course, we have only heard one side of the argument so far. In that case, we'll continue at 10:30 tomorrow. Thank you all very much.
All right.